Imagine waking up one morning to find a tow truck in your driveway, ready to haul away the car your husband needs to get to work, even though he has made every single payment. Not missed one, not skipped one. Paid every month, sometimes a little late, but always paid. And somehow, the loan company is still trying to repossess the vehicle. That is exactly what happened to a couple in Missouri, and when they finally figured out why, what they discovered was almost unbelievable. This is the kind of story that makes you want to check your own loan accounts the second it's over, and by the end of this video, you'll know exactly what to do if something like this ever happens to you. So let's set the scene here. A husband and wife in Missouri. He has a car loan. Nothing exotic about this situation. Millions of Americans carry auto loans, make their payments, and go about their lives trusting that the financial institution on the other end is doing its job correctly. That trust is usually warranted. Usually. But this couple is about to find out what happens when it isn't. The husband had been making his car payments every single month starting back in January. He was not perfect about timing. Sometimes the payment came in a little late, but it always came in. The money was leaving their account and going to the loan company. As far as they were concerned, they were holding up their end of the deal. The loan was being serviced. Life was moving forward. What they did not know, what they had absolutely no reason to suspect, was that since January, the loan company had been doing something very strange with those payments. Instead of applying them to the husband's auto loan balance, the way any reasonable person would expect, the company had been routing the money into something called a trust account, a separate holding account that had nothing to do with paying down the loan. The payments were just sitting there, not being credited, not reducing the balance, not being applied to anything that actually mattered for the loan's standing. The couple did not bank with this institution. They had no relationship with them beyond the car loan itself. So there was no reason for a trust account to exist in the first place. They had no idea this account even existed. And the loan company, for whatever reason, never reached out to say, hey, your payments are going somewhere unusual. You might want to look into this. Nothing. Silence. Months went by. January, February, March. The husband kept paying. The money kept disappearing into this mystery trust account. And then, out of nowhere, the loan company came knocking. Except not with a letter or a phone call asking for clarification. They came with the threat of repossession. They declared the loan delinquent. They said the car was going to be taken. The wife, understandably panicked, went online looking for answers. She posted their situation to a legal advice community, and the responses started pouring in immediately. But before those responses even had a chance to make a dent, the husband did what most of us would do. He called the loan company directly. And here's where things get even more infuriating. When he called and explained what was happening, the company acknowledged the trust account situation. They fixed it. They moved the money over and applied it to his loan. Just like that. Which raises an obvious and absolutely maddening question. If this was something they could fix with a single phone call, why did they let it go on for months? Why did they never flag it? Why did they let it escalate to the point of threatening to repossess a vehicle from someone who had been faithfully making payments? But it got worse. Even after they corrected the trust account error and applied all those payments to the loan balance, they still said they were going to repossess the car. Their reasoning? He owed the April payment and associated late fees. Now, here's the thing. The April payment was not even due yet. The due date was the 21st of the month. This conversation was happening before that date, and the couple knew they would have the money by Friday, just days away. So now we have a situation where a man who has been making his payments every month is facing repossession over a future payment that isn't late yet, combined with late fees that arguably should not exist at all, given that this whole mess was caused by the loan company's own internal accounting error. The wife asked the online community a series of very reasonable questions. Is this even legal? What happens if they hide the car until Friday to buy time? And can they dispute the damage this has done to their credit score? The community came alive with responses. Legal professionals, people who had been through similar situations, consumer rights advocates, all of them weighing in. The consensus was pretty consistent. First, the hiding the car question. Technically, once a vehicle is declared in default and a lender has the right to repossess, concealing the vehicle to prevent repossession can create legal problems, depending on the state. Missouri has specific rules around this, and while the couple's situation was clearly caused by the lender's error, hiding the car is generally not the move you want to make. It can complicate an already messy legal situation and give the lender ammunition against you. The stronger advice that kept coming up again and again was this: get an attorney, specifically a consumer protection attorney or someone familiar with the Fair Debt Collection Practices Act and auto lending laws. What the loan company did, misapplying payments for months and then attempting repossession while the account was technically in their own error state, has the hallmarks of a serious legal violation. A competent attorney would look at this and see potential claims for wrongful repossession, negligence, and possibly violations of federal consumer protection statutes. Then came the update. And honestly, for a story that could have ended very badly, this one had a moment of grace. Their tax refund arrived. Right in the middle of all of this chaos, the money showed up. They made the April payment and paid the late fees. Not because they agreed the fees were legitimate, but because they wanted to stop the immediate threat of losing the car. Smart move. Get the car safe first, then fight the battle. And they confirmed they were going to speak with an attorney. Because here's the thing. Paying that late fee to protect the car in the short term does not mean you have to accept the situation permanently. You can pay under protest, as lawyers sometimes say, preserve your rights, and then pursue what you're owed after the crisis is resolved. So what does all of this mean for you? What can you actually take away from this family's nightmare? The first lesson is to never assume your payments are being applied correctly just because the money left your account. Get in the habit of occasionally logging into your loan servicer's website or calling them to verify that your balance is going down the way it should be. This sounds tedious. It is tedious. But this couple had months of payments sitting in a trust account they didn't know existed, and they only found out when the repossession threat landed on their doorstep. A simple account check back in January could have caught this immediately. The second lesson is to document everything. Every payment you make, save the confirmation. Screenshot it, email it to yourself, print it out, whatever your system is. If a dispute ever arises, having time-stamped proof of every payment you've made is worth its weight in gold. In this couple's case, proving that payments were made and received, just applied incorrectly, was the difference between a clear-cut case and a messy back and forth. The third lesson is to know that the Fair Credit Reporting Act gives you the right to dispute inaccurate information on your credit report. If your credit takes a hit because of someone else's accounting error, you can and should dispute it with the credit bureaus directly. You can also request that the lender provide a letter of correction, which a good attorney can help you obtain. Getting that negative mark removed may take time and persistence, but it is absolutely possible when the negative mark stems from the lender's own mistake. The fourth and most important lesson is this: if you are ever in a situation where a financial institution is taking adverse action against you because of their own error, get an attorney involved quickly. Not after you've tried to handle it yourself for weeks. Not after the car is already gone. As soon as you recognize that something is wrong and the company is not making it right, pick up the phone and call a consumer protection attorney. Many of them offer free initial consultations. You might have more legal power in this situation than you realize. Lenders make mistakes. Sometimes those mistakes are sloppy accounting, sometimes they're more than that. But either way, you do not have to just absorb the consequences of someone else's error in silence. The law exists specifically to protect consumers from situations like this. If this happened to you, if your payments are being misapplied, if your credit was damaged by a lender's error, or if you're staring down a repossession threat that doesn't make sense, do not wait. Contact a consumer protection attorney in your state as soon as possible. You have rights, and you deserve to have them enforced. If you found this video helpful, please subscribe because we cover real legal stories like this one every week. Situations that could happen to any of us, and the lessons that help us navigate them. Your next watch is already queued up.